Check, mic check, check, check. Nope. Maybe it's just there. It is. It'll just like kind of focus on whoever's kind of talking. Won't really get too much of this right here because it doesn't really reach this side, but it'll follow you like wherever your voice is.
and also there are the one case.
Well, so the meeting will now come to order. Welcome to this meeting of the Charlotte Alternative Compliance Review Board on Wednesday, December 3rd, 2025. My name is Kent Main. I'm chair of the board. With the board members, please go around.
Evening, Your Honor.
Tammy Schamberger.
Spencer McGill.
There are 4 present. We normally go with 5, but with 4, that means that the applicant has the right to defer if you choose to do so in order to have 5, so that there might not be a tie vote or some other such thing happen. Are you comfortable proceeding with 4 members of the board? Absolutely. I'm seeing nods in affirmative. Let's also have the staff go around and state their name and their position for the record.
I'm Paige Inman with the City Attorney's Office, legal advisor to the board.
Charlotte Kuskader, Urban Design Center.
John Finley, UDO Administration Planning Department.
Kristen Moskier, UDO Administration Planner.
Rachel Blake, UDO Administration Assistant Planner.
Elizabeth Majors, Court Reporter.
Terry Hagler Gray, Senior Assistant City Attorney.
Solomon Forces, Charlotte Building Administrator.
So we will now move to the recommendation agenda items for alternative compliance. And I have this wonderful script here, so we will read through this. We did hear this case presentation at our last meeting, so I guess I still need to do all of this. Is that right?
That's correct. This is, because this is a new hearing, because as you know, for the record, as per last month, we did, the applicant did request they requested an additional, deviation from one of the requirements. We, on our presentation, we had both of them, but on our official notice to the public, we did not. So in an abundance of caution to the applicant and the staff, we felt it was probably better to defer, and then so we can properly notice, just in case if someone out there says, I have an issue with the request, they would clearly know what the applicant was asking.
So we will proceed. Each of today's hearings is a quasi-judicial evidentiary hearing. This means that it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it will only be given limited weight. Parties with standing have rights to fully participate. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show that they will suffer special damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you've not done so, please do so now. Yes, no? The parties to each case are entitled to an impartial decision maker. A board member may not participate in the hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with the affected person, with county person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, one case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by any affected party. Hearing procedures today. Today's meeting will follow the order printed in the agenda. The order of the recommendation agenda will be as follows. All parties entitled to give testimonies must be sworn in. A city staff member will present a summary of the case, and then the board may question the staff member prior to entering into deliberations and making a decision. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the alternative compliance request. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations. The UDO administration staff will transmit a copy of the decision letter after the meeting. If you are not the applicant and wish to receive a written copy of the decision, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. All right, so presentation of cases. We will now open the evidentiary hearing for case number 2025-00003. The property is located at 700 East Martin Luther King Drive, Junior Boulevard, parcel number 125-07126. Before we begin, does any board member have a conflict of interest or potential conflict of interest to disclose?
No.
Hearing none. Have any ex parte communications or site visits been made that need to be discussed?
No.
Hearing none. At this time, I will administer the oath of individual for all individuals who intend to provide witness testimony. Will the staff and any members of the audience wishing to speak come to the front of the room? We have sort of this. Who's going to be testifying? Sure. Do you have next one? So the oath. Do you solemnly swear or affirm that the evidence that you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so we'll have this presentation.
Hey, Bob. So as Kent teed us up for, today we are here for case 2025-00003. The applicant is the Shawnee Mecklenburg Board of Education, and the address of this parcel is 700 East Martin Luther King Jr. Boulevard. The zoning is UC. And this request is for alternative design from Article 12.3E transparency, table 12-4, row B. And that is to reduce the minimum ground floor transparency for non-residential and mixed-use development fronting Martin Luther King Jr. Boulevard from 60% to 12%. There's an additional alternative design request from Article 12.3E, transparency, Table 12-4, Road C, to reduce the minimum upper floor transparency per story for residential, non-residential, and mixed-use development fronting Martin Luther King Jr. Boulevard from 15% to 11%. You can see the vicinity map here shows the site in question. And the alternative compliance is only applicable for the southern portion of the site highlighted here in yellow. The site is known UC as previously mentioned. And it is a uptown primary street for both of the frontages, one being on Brooklyn Village Avenue and the other East Martin Luther King Jr. Avenue. And this is in Exhibit 4, and the street classification, this sets the transparency requirements. So that's why that is important for us to take into consideration. Exhibit 5 is the request, which again is for the ground floor transparency to be reduced from 60% to 12% along Martin Luther King Jr. Boulevard, and to reduce the minimum upper floor transparency on Martin Luther King Jr. Boulevard from 15% to 11% on each one of those floors. This is in reference to Article 12.3E, dimensional and design standards for transparency. Since these are uptown primary streets, those are translated to other primary within the UDO. So that's where we get the 60% for ground floor and 15% for upper floors. For all alternative compliance requests, there are general criteria that these must meet. The first is that the applicable standard shall be reviewed to determine that the alternative compliance meets or exceeds the applicable review criteria. The second is that the alternative compliance proposal for standard shall be consistent with the intent of the applicable zoning district and the intent of the specific standard. The third is that the fact that the property could be utilized more profitably or conveniently with alternative compliance than without alternative compliance shall not be considered as grounds for granting alternative compliance approval. For dimensional standards specifically seeking alternative compliance, there are 3 additional requirements, and those are that the design meets and maintains the intent of the original standard and the purpose of the zoning district, that the design maintains pedestrian safety and walkability, and that when alternative compliance is applied for transparency, as this item is, the building design includes elements that facilitate the enhancement of a ground floor pedestrian-oriented environment. Anything special? Okay. Exhibit 7 shows the proposed site plan. As you can see, the frontage that is requesting alternative compliance, Martin Luther King Jr. Boulevard, is where the additional elements are. So there have been 2 accessible seating areas provided, as well as a pedestrian plaza and seawall. And they're going to keep the remaining street trees. So this, no, we're headed that way anyway. For exhibit number 8, this is an elevation of the Martin Luther King Jr. frontage. You can see that the seawall and plaza is shown, as well as the commitment to artwork that is going to be between that 3 feet from ground level to 10 feet between ground level, and will cover that area. And then we've got accessible bench seating area that's not shown. The area circled in red is the Brandel glass window openings. So these are committed to and can never be covered with any type of, film or advertisement. It's not the correct word, we'll get there. So all of this written out shows that to ensure the design meets and maintains the intent of the original standard and purpose of the zoning district, the applicant will utilize the spandrel glass window openings on the upper floors in locations where interior uses are incompatible with transparent windows. This glass does not count towards minimum transparency calculations, and utilizing it in window openings will create a uniform look across the facade and the illusion of upper floor transparency. On the Martin Luther King Jr. Boulevard facade, the applicant commits to, on the second floor, a minimum of 210 square feet of the spandrel glass, or 7.6% of that facade. That number is the same on the third floor. And for the fourth floor, it is a minimum of 63 square feet, or 5.7% of spandrel glass. And then this is the correct phrasing that I was trying to get at earlier. No future addition of digital graphics or window film will be installed over that glass. To ensure the design meets and maintains the intent of the original standard and purpose of the zoning district, this site will also be held to educational facility use only. To facilitate the enhancement of ground floor pedestrian-oriented environment, the applicant has agreed to provide street furnishings along Martin Luther King Jr. Boulevard as generally depicted in the site plan. That includes 2 bench seating areas designated to meet accessibility standards, enhanced with supplemental plantings, as well as a pedestrian plaza incorporating an integrated seat wall, providing a minimum of 40 feet of seating. To facilitate the enhancement of a ground floor pedestrian-oriented environment, the applicant has agreed to utilize at least 516 square feet of artwork to address the blank wall condition between 3 and 5 foot from grade on Martin Luther King Jr. Boulevard, generally as depicted on the elevation. Artwork options include mural, relief, or digital graphic, and the proposed design is to be collaborated with community input. To maintain pedestrian safety and walkability, the applicant has agreed to keep 2 existing ginkgo trees along Martin Luther King Jr. Boulevard. And this is all captured in Exhibit 9. Exhibit 10 shows the sign on the site alerting the public that this case is happening. And Exhibit 11 is the conclusion of law, which I believe we might have wordsmithed a little bit, but we're pretty close. So alternative compliance for the applicable standard has been reviewed and determined that the alternative compliance meets or exceeds the applicable review criteria. Alternative compliance proposal for the standard is consistent with the intent of the applicable zoning district and the intent of the specific standard. The fact that the property could be utilized more profitably or conveniently with alternative compliance than without alternative compliance has not been considered as grounds for granting alternative compliance approval. The design meets and maintains the intent of the original standard and the purpose of the zoning district. The design maintains pedestrian safety and walkability, and the building design includes elements that facilitate the enhancement of a ground floor pedestrian-oriented environment. That is all.
Does the board have any questions for the staff?
So unfortunately, since you were not here from the very beginning, you can't participate in the deliberation, but board members have to be here for the entire meeting. There were additional cases participated, but unfortunately with this one. Thank you.
All right, so no questions for
No.
anyone? This concludes the presentation of evidence and the hearing is now closed. The board will now begin its deliberation. As a reminder, this board is tasked with deciding if, based on the evidence presented, this case meets the applicable standards. The decision cannot be based on personal preference of the board members. Rather, it is based on the standards and evidence. Board members are encouraged to reference the applicable legal standards and specific evidence in their deliberation. No further discussion.
No.
Is there a motion to approve with conditions, or deny the alternative compliance request?
To approve. Second,
Can we clarify that that is approved with the conditions?
with the conditions. Second.
Any discussion of the proposed findings of fact? Is there a motion regarding the findings of fact?
Can we clarify that we vote on that first motion? There was a motion and then a second. There was a vote, sorry, I missed that.
I'm still confused about why we're voting on the motion before we vote on findings of fact, but so be it. All right, on the motion, before the floor, which is to approve, with conditions, all in favor? And I see 4 hands. All right, now we need a motion for the findings of fact.
A motion to approve and conclusions of law and conclusion.
All right, a second to that,
Second.
and all in favor? 4 yeses. No dissents. Then the motion is approved. This concludes the hearings on today's agenda. The next agenda item is the approval of the November 6th, 2025 minutes.
So technically that was left off the agenda. I think, are we ready to have it? Okay, so that was actually let off. Yes, if we could do that. So there are no more items.
Okay, so the minutes will be looked at, I guess, for the next meeting.
Correct.
All right. This concludes the hearings on today's agenda. The next agenda item is the approval of, we already did that. Has everyone had an opportunity? No. This concludes today's agenda. Thank you for coming. This meeting is adjourned as of 10:27 a.m.